If you're charged with a crime in Massachusetts and you miss one of your court hearings, the judge can, and often does, issue a default warrant for your arrest. So if you go to district court and you sit through the criminal session in the morning, you will see this happen. You will see the judge issue default warrants. And they do it for all types of hearings. So if you miss arraignment, pre-trial hearing, trial readiness conference, there are even defendants who don't even show up on the day of their trial. In any one of these situations, the judge can issue a warrant for the defendant's arrest. Now, in theory, court could start at 9 a.m. The clerk can call your name first, and if you're not there, the judge can issue a warrant. Now, it almost never happens that way. Usually what happens, court opens sometime between 9 and 10:30 in the morning. They go through the first call of the list. Now, if you're not there for the first call of the list, what usually happens is your case gets placed on second call. So the court will go through the first reading of the list. They'll deal with all the cases that they can deal with, and then they'll go back to where they started and start calling the cases for a second time. This second call usually happens around 10:30, 11 o'clock. Could happen earlier, could happen later. Now, if you're not there for the second call, the judge is likely going to ask your lawyer if the lawyer knows where you are and if the lawyer has had contact with you. So if the lawyer says, "I've had good contact with my client," that's a good first step. Now, if the lawyer has had no contact, that's not good for the defendant. Next, the judge will turn to the prosecutor and ask for the prosecutor's input. Now, sometimes the prosecutor will take no position, but very often the prosecutor will ask the court to issue the warrant. Then, after hearing from defense counsel and the prosecutor, the judge will usually look at the defendant's record, which will show both the number of crimes he's been charged with and, more importantly, the number of times he's defaulted at prior hearings. Right? So it's sort of a totality of the circumstances situation, whether the judge will issue the warrant or not. If defense counsel has not heard from the defendant, if prosecution is asking for a warrant, and if the defendant has a history of default, the defendant will absolutely be subjected to a warrant. All right? Or any variation of those things, the judge would issue a warrant. So it's very important to go to court, to be in contact with your lawyer. Now, if something unexpected happens on the day of a hearing, like your car breaks down or something like that, call the clerk's office, appear on Zoom, do whatever you can to make it clear to the court that you're still very much involved and concerned with your case. And just do the best you can to avoid the judge issuing that warrant. I've written a blog post on this, and I'll put it in the description below.